So let me pose something to you all. Let's say you are at an arraignment, at an initial appearance for a client, and maybe it's a private client who hires you and says, they told me it's a summons, so to come to court on this day, and you go to court with the client, and you, based on the information the client has told you, or the information you've learned now since you've been there, if it's an appointed case, it seems at first blush it's just going to be an arraignment, question of bail, and then that's it. And you get into court, and all of a sudden probation is saying, oh, no, wait, this person's still on probation for something else. And maybe it's, an older case where they just owe money, but the probation officer is really out to get them, and they're looking at a suspended sentence. So you have the probation detainer out there. You're looking at your client and you're thinking, this client has some, there's some serious substance use disorder issues in this, and there's some talk that maybe a family member is going to come in and file for Section 35. What's your and I could have picked any of the 2 of the 12 we've talked about. What are you thinking might be a way of approaching that? Right, so you now have a bail situation. You have a probation detainer potentially that will hold your client, and you have a family member who wants to petition for a Section 35. You don't know enough about the case to say what you're going to do, but what are the questions you're going to ask? What are you going to be thinking about? Who's not up here? Yes, sir.
The likelihood of him being detained.
Right.
How serious is it?
Okay, so the answer was, how serious is it? And the first comment was, what's the likelihood of him being detained? So I think you're onto something. For me, when I look at these, the first question, back to one of my previous slides about the consequences of being held, which are just devastating, and there's all this studies, even 3 days of being held can ruin someone's life, because we are talking about people with not a lot of stability to start. So to me, the first question is, of all the pieces I'm looking at, which is the one that's most likely going to result in my client's detention? And that then becomes the focus, right? How can I defeat that? And then I tackle everything after that, right? And so if it's a question of a probation detainer or a 58A or a bail revocation, a no bail situation, I want to take on that first. And then secondly, I want to take on the imposition of the bail, right? Because then I know I can always, even if the bail's set way too high for my client, I have remedies, right? I can come back on a bail review. I can argue in a changed circumstance. I can attack that. So for me, the way I've always sort of approached these is, what's the hierarchy of needs? What's the way that I can sort of do the least amount of harm to my client in the process? And if the client is lying on the floor going through some kind of, drug withdrawal, that may become the most significant thing, right? For the client, that might be the biggest need they have right there, is what of all the solutions can get this person into some kind of treatment? And maybe it is a bail, right? And maybe some kind of bail, but with the condition that they go into a drug treatment. Maybe that is sort of what I do. So these are really, really, really complicated. And sort of just to in our last few minutes, to throw some more complications into the mix.
No, I'm saying
we have someone online. This is very exciting.
I can't read it, but it looks longer than it was before.
All right, could Chris give some examples of his favorite motion for ... That's you. All right, so yes, we heard you online, and before I loop us all the way full circle with some ethical considerations, Chris is going to tell us his top few motions for ...
All right.
Great question. Put him on the
So
spot.
I've used it oftentimes for blackboard motions when I have, I don't want my client to be out in court. I've used it for, to get criminal records of complaining witnesses at arraignment, so that I can argue that, that their prior records may either make their credibility an issue or their likelihood of responding and following through with a case unlikely. I've used it to try to get an order of certain records that weren't privileged or confidential, but potentially helpful to me at an early stage. I used it once to get the CV of a dog in a drug sniffing case. What else?
Ooh, I have one.
Go ahead.
Pretty good.
Return of seized property when they've taken the client's backpack with the paycheck in it, and
Excellent.
that's not evidence, but they could really use it to pay rent.
Another one I'm thinking of is if you have, at arraignment, it's clear, or you have a really good argument that there's no real probable cause supporting your client's arrest, you could do a motion to dismiss the dismiss the complaint prior to arraignment. And I see a parallel if there's a probation detainer, because on probation, they also have to find there's probable cause to believe they violated their probation, so you might have that there. That's another one I think of.
The two cases, if you get a case where you think there's a missing element at arraignment, the two cases are cited in my PowerPoint, not with their sites, but by name. You need to read Umberto H. and Di Benedetto and combine the analysis of the two, and you can make the argument that a case should be dismissed prior to arraignment. Sometimes judges will not hear that motion at arraignment, but they might be willing to stay the arraignment to give you a chance to litigate that motion if it's a strong enough argument. And so I've also filed a motion to continue the arraignment so I can have the opportunity to file a motion to dismiss prior to arraignment. And obviously the value of that is if you are successful, you prevent an entry on your client's carrier, Corey, which is huge.
Okay. That was a great question from online. Any other questions from online? Okay. All right, so the last thing I want to talk about, and I promise to do it quickly, is sort of underlying everything we do as criminal defense lawyers is our ethical questions. And for lots of reasons, I feel like this comes up. Well, I don't know if it comes up more at arraignment and first appearance, but it certainly is highlighted at arraignment and first appearance for a couple reasons. One, everything happens so fast, so you don't have time to really think and prepare. When you're getting ready for a trial, you have time to think and prepare. Well, what if my client wants to testify and they want to testify about something I know is not true or something that's different than what they told me before? You have time in your trial prep to think, now, how are the ethical rules, going to come into play on that, right? But at arraignment, at first appearance, you've got like all these balls coming at you, and so you don't have the time to sit and research and think and mull it all over and talk to your colleagues. So that's one reason why I think the main reason why sort of ethical concerns are coming up earlier. And the other is that, your client, you don't have a relationship with your client yet for the most part. So you can't rely on sort of what your client says to you being the most helpful in what you need to tell the judge, right? So, if there's a spectrum of you and your client cooperating and working together for the same end goal, it's going to be much more so as the case evolves. It's going to be much less so when you haven't even met your client for obvious reasons. So that's sort of what I think about when I think about ethical considerations here. All right, I had an amazing revelation, and it was a little sad, a bunch of years ago when I realized that despite, deciding to commit my life to being a public defender and thinking that I want to, confront the establishment and fight the power and all that, that rules are actually really helpful, and rules are good, and rules are important. So I got over my, fight everything and just sort of accepted that in some ways we need to know the rules and we need to be comfortable and embrace the rules. And the rules I'm talking about specifically here are the rules of professional responsibility that govern our conduct as attorneys and our relationships with other people in our role as attorneys. And also, if it is a court-appointed case, if you're appointed through CPCS on a case, there are the CPCS performance guidelines, which are part of your rules as a court-appointed attorney. So I think if you take nothing else away from the ethical piece of this, if you look at those two sources at the rules, they will help you make almost any decision you have to make at arraignment or any other time when it comes to the ethical rules. So I'm just going to highlight 3 rules that I think come up the most in our practice and specifically at first appearance. Okay, so rule 1.2a, which, not that anyone needs to know this, and I wouldn't if I didn't have it on my sheet in front of me. But that is the rule that talks about what decisions are the client's decision to make and what decisions are the attorney's decision to make. Is anyone sort of back in the recess of their minds, or we have some law students here maybe in the closer to the front of your mind, what are the decisions that, that a client gets to make?
I literally said one during my presentation.
There's 3 things that are absolutely only up to the client, and the attorney cannot make them for them.
4 in Massachusetts.
4 in Massachusetts, sorry, yes. This is what I need the smart professor here, yes. Trial, okay. To go to trial or not. Excellent one. What else? To testify, okay? So if the client's going to testify, that's up to the client.
What about our online people? I can't tell if they're answering or not.
No, they
Come
have
on,
not. They have
online
not.
people.
Shouting criminal responsibility.
Yes! Yes.
And there's one more, which is whether or not the client wants to waive the jury and go with a bench trial. Okay, so does that mean none of those things, with the exception of the criminal responsibility, but really in general, let's just say, none of these things have to do with arraignment, right? I mean, this is not going to, for the most part, you're not going to be dealing with these issues at arraignment. So does that mean every single decision you make at arraignment is yours and yours only to make? You decide, and then that's it. I see a head shaking with a stupid question from the front. No, why are you shaking your head? Why are you getting so annoyed with me? I'm just kidding. You don't have to actually answer that. You have a privilege against self-incrimination.
I mean, a point was brought up earlier about whether or not they wanted to sort of plead with the probation officer, for example, or to go ahead and decide, okay, listen, it's better for you to go get treatment than to be detained. Maybe they really don't want to go to treatment. Maybe they'd rather be detained. And
Right.
we tend to think this is in your best interest, but maybe they have other reasons.
There was a slide that I didn't get to talk as much about that I would like to have earlier in my presentation. We're talking about goals. What's the goal? What are we trying to accomplish? And there's a saying, which I'll get wrong, it's not about lemons and lemonade, but you know, about what happens when you make assumptions, right? And I think I had a picture of a donkey. So the point is, we do not assume, we should not, and we cannot assume that we know what our clients' interests are until we ask them, until they tell us. Because you're right, I have had clients in the course of my representation who want to go to jail, who are homeless and it's cold and they want a place to sleep and it's on something minor, they know they'll be out in a few months. That is not my place to say that's a wrong decision to make, and it's not my place to assume. So while the rules give us these categories, they also contemplate that we should be consulting with our clients, and it should be our clients' interests who we're advancing. Okay, the next one is confidentiality, all right? So lawyers should not reveal confidential information unless the client consents after consultation, except certain kinds, which we're not going to get into now. So here's the first appearance issue where I think this comes up the most. I meet with my client, Tracy, and my client Tracy says to me, I asked some wonderful open-ended question about Tracy's hopes and dreams in her professional career and what it is she does for work and what she hopes to achieve with her life through this work. And in that conversation, she ends up telling me that she works at Target. And she has been working at Target for the last 4 years, and she is the reigning champion of people at Target who have been Employee of the Month so many months in a row that they have, created a whole new award called the Tracy Award. Okay, she is the best employee that has ever come to Target. So what am I thinking? Well, that's awesome, right? Like, cha-ching, bail argument won. I'm totally excited because what judge is going to say, I'm going to hold Tracy even though the entire functioning of Target goes on, falls on her shoulders, okay? So I'm thinking this is great. Now, what do I have to do to be able to say this in front of the judge? To make it more persuasive is I want to say to the judge, I talked to her boss, talked to the manager of Target, and he told me that, in fact, she was the Employee of the Month, 12 years and running, even though she's only worked there for 4, so that would be weird. Okay, any ethical considerations coming up yet for anyone? Yes?
Red flag is, how about if her job doesn't know that she has been arrested
Right.
and dealing with this?
Right. So the question, the very smart person in the audience said, what if her job does not know that she's been arrested or she's dealing with this? So should I be calling Tracy's employer just because it's the right thing to do and it's going to get Tracy out? No, right? I have to talk to Tracy first, okay? And I have to ask Tracy if I can do that. And the other thing is, before I can say anything to the judge that Tracy has told me, be it about her job or be it about her family situation or be it about anything, I need to tell Tracy, I need to ask Tracy, I would like to tell the judge these 5 things you just told me, because I think it will help you, help us in getting your bail set in personal recognizance. Are you okay? Is it okay for me to talk to the judge about this?
So I have a slightly different twist on that. I think telling the judge that Tracy works at Target is implicitly authorized under the rules based on the conversation, the context of the conversation. I would never call the boss without permission, and I would never tell the court that my client also has AIDS or cancer or whatever else without specifically asking. But my client lives at 12 Jones Street, has worked here, and went to high school. I think based on the context of that interview, I think there's an implicit authorization to volunteer that information without explicit permission.
And I think we're both right. I mean, and these are just 2 different lawyers with a slightly different take on the same thing. I think, Chris's point is good in that she has probably not just told me that she works at Target, she also told probation when they interviewed her for her, does she qualify? She may have told the police when she was booked, right? So there may be information that is not just information she told me. But I think you would agree, anything she just told me or anything of a sensitive or personal nature.
Anything that's sensitive and personal, absolutely.
Right.
If I don't know, if she told me she had 3 children and I start the conversation by saying, I'm going to get a bunch of background information for you to use in a bail argument, which is how, so then to me, I think I can use discretion around that, and I don't think there's an ethical violation. I don't think there's any harm in going back through and doing what you're talking about, but I don't think it's unethical to make a reasonable assumption around that.
And I agree, the ethics, I would not, Chris would be correct. He is absolutely correct. I just like to take it the next step for some of this. But again, this is not a major disagreement in any way. All right, Tracy.
Before you move on from confidentiality.
Yes, since we are talking about you and your
and
stellar employment at Target.
Yes. One of the issues that comes up a lot with competency is in direct contradiction to the ethics rules on confidentiality, because you as the attorney are the one bringing this to the court, not the client. The client's not going to be saying to you, I'm not competent. I don't have a rational understanding of what's happening here. And in order to raise that issue, you are going to have to disclose some things. Sometimes you don't have to. Sometimes you can just say, Your Honor, I have, some issues. I'd like the court clinician to come speak to my client, and that'll be it. But the clinician's going to ask you, what are your concerns? So there is some friction between confidentiality and bringing competency issues to the court's attention. You do owe a duty of candor to the court, and you do owe it, I think, to your client not to push them through the process when they're not understanding what's happening. But it can be an issue, and I always tell people, as the attorney, you raising the competency question may cost you your relationship with the client. Your relationship with the client might not survive that, which is okay. If the client ends up competent, they might end up with another lawyer, but that's okay.
And Tracy just previewed what is often in conflict with the value of confidentiality is Rule 3.3, right? No false or material facts, statements of material fact to, yes. You can't lie to the court, okay? Or you get a Pinocchio nose. So, how can you imagine, or how have you seen this come up in first appearance issues? Has anyone seen this? Sort of the conflict between information you learn from your client and not making false statements to the court. Clients lie to you sometimes, yep.
Yeah, I was going to say that. I get a lot of, I don't have a record. I don't have nothing on my record. It's absolutely clean. And then when I go to probation, thank God, before I even open my mouth, it's like,
Right.
what is that?
Chris, I know this is your this is like
Yeah,
your
so
favorite
this issue,
topic
at
of
least you don't-
conversation.
So at least with that, you don't have to, you don't have to dime out your client because the court's already got the record. You don't have to say to your client, I've got an obligation. You just go to your client and say, I want to help you, and it helps if you're honest with me, and this is what they came up with, and let's go through this. I think the most common scenario where you run into this at arraignment is the false name hypothetical. And if your client has given somebody else, like probation, a false name, and is actually being arraigned under a false name, somebody with no record, and reveals to you that that's not who they are, that is one of the worst positions that a defense lawyer can ever be in, because I believe you have an affirmative obligation to correct that situation. Now, the way you do it is you try to get your client to be on board so you can make it all about your client coming clean, but it's a horrible situation to be in. I've had this issue come up where clients have said, that's my mom in the audience, and I give a bail argument talking about mom, and then afterwards the woman in the audience says, I've never met that guy before, right? And Rule 3.3E requires you to, as soon as practical, remedy when you put forth misleading or false information to the tribunal, right? So it can come up in a variety of ways at arraignment, but the false name one I think is the most common one, and that's a horrible situation to deal with, and I think 4 out of 5 times you lose the attorney-client relationship out of it. And the ethical rules and opinions interpreting this do not allow you to punt. In other words, you can't say, I'm going to withdraw and let him lie to some other guy next and hope the other lawyer, cross my fingers, they don't figure it out. The ethical rules do not allow you to do that.
And this is not a pushback from what Chris says, because I absolutely agree with him. But I will say, just make sure the problem arises if you know it's false, right? There's a lot of gray area. And I was recently talking with someone who's helped me a lot in thinking about how to best represent transgender clients. And one of the scenarios that he sort of had proposed to me was somebody whose record says Joe Smith, but Joe Smith now goes by Josina Smith, all right? And so now, and wants to be called Josina Smith when you make your thing. Now, is that a false statement, right? Does it matter if they've actually legally changed their name? That it's a whole different, and I mean, I couldn't even begin to get into it in the next 30 seconds.
But if it pops up no record, then you've got a different issue, right?
Exactly. So these are, we can do another whole program on this. The last thing I'm going to say, and then I promise I'm going to stop talking, is as other people were talking today, I was looking through this book, and there's some freaking amazing stuff in here. I didn't realize how good these materials were until I looked at them all at once. We've got an outline I did, some outlines Chris has done, sample motions, the flow chart from Tracy and the different section charts. This is gold. This is really worth the price of admission. And I hope you will use these materials. I hope you will find them helpful. If you have any follow-up questions or anything that comes up as you're embarking on this, please don't hesitate to contact any of the 3 of us. And we really appreciate your coming and listening to us today. So thank you.
Thank you.